Hi, everyone. Welcome to the 2023 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow. I'm Dean of Vermont School for the Environment, and we're very pleased to welcome you to the presentation today. Each of these talks is worth one CLE credit in Vermont, so if you'd like to claim that credit, you just need to keep track of which talks you attend for your reporting records. We'll have time for Q&A after the presentation today. And if you're watching on the VLGS YouTube or Facebook pages, you can enter your questions in the chat or the comment space. And those will then get to me and I'll get through as many as I can. Today, we're very pleased to welcome Mavis Gragg. Professor Gragg is a self-described death and dirt attorney and conservation professional, empowering families to use real estate as a source for intergenerational resiliency and wealth. She currently serves as the director of the Sustainable Forestry and African American Land Retention Program at the American Forest Foundation and is the CEO of HeirShares, which is building groundbreaking technology to facilitate affordable solutions for family real estate ownership. Professor Gragg also chairs the North Carolina Parks and Rec Trust Fund Authority and previously chaired the board of Triangle Land Conservancy. Professor Gragg joins us this week as one of our summer faculty, teaching a new weekend course at VLGS called Protecting Family Land, Heirs Property. And today, she'll present Strong Roots, New Growth, Unlocking the Potential of Heirs Property. Please join me in welcoming Mavis Gragg.
Thank you, Dean Rushlow. Very excited to be here. My second time in Vermont, but certainly the most substantial time. I only passed through before, but very happy to be here and very happy to, or excited to share about Heirs Property today and this weekend with the 6 lucky students who get to take the course, or who I get to have a course with. So thank you for having me. And today, since this is a hot topic and we have about an hour, I'm going to talk about what heirs property is and what the legal challenges are the heirs property owners experience. We'll also talk about the initiatives that are addressing heirs property, including HeirShares, my company, and the incentives related to heirs property preservation. So very excited to dive in. Usually when I present on heirs property, it's to non-lawyers, although I sometimes get the chance to talk to lawyers about this. Often it's foresters and other professionals, as well as landowners. And usually when I start this presentation, I say we're going to go back to law school, which generates lots of laughs, but we are in law school because this is the law school that I'm presenting to. So happy to be back in law school and looking forward to your questions and a lively discussion after my presentation. You've heard a little bit about me. The only thing I can add is that I will be moving to New England in August. I have been invited to be a Loeb Fellow at Harvard, so I'm excited about spending time up here, and I hope that that means that I get to do more with CAFs. I also have been collaborating with Fran Miller in the Center for Ag and Food Systems on building a network of heirs property practitioners, so attorneys who do this work, and that's been very exciting for me as well. I would like to contextualize this issue first within the context of the African American community, but certainly many people own heirs property, and you'll understand why in a little bit. But within the African American community, the history of ownership of real estate has been pretty tenuous and has been pretty violent even. If you think about the legal system, the legal systems in the U.S. and the restrictions and various laws that made it illegal and very difficult for folks to own real estate in the 1800s. It's been pretty challenging. Owning real estate in the U.S., in my belief, is an act of defiance for some communities. But within the African American community, really didn't start owning real estate until after slavery ended and new laws were implemented that made it legal to own real estate. And within a short period of time, the African-American community accumulated an incredible amount of real estate. And the numbers show that it was close to or over 20 million. However, that is when the African-American community peaked in real estate ownership in terms of the amount of real estate we owned. Over the last 100 years, we have lost most of that real estate. And a lot of it has to do with, systemic racism, redlining, Jim Crow laws, gentrification, theft, and partition sales. And partition sales continue to play a major role in the loss of real estate within the African-American community, but also in other communities as well. Heirs property is often couched as a problem. Heirs property itself is simply real estate owned by family members who have inherited their shares. And the form of ownership has been a form of preserving family wealth for many generations. However, it's the legal structure of heirs property that creates vulnerabilities that contribute to loss. So I don't think heirs property ownership is a bad thing. I think our legal system doesn't support co-ownership by families over generations. And so we've seen a significant amount of loss, and that has led to initiatives to preserve heirs property and to help families develop new strategies for how they maintain real estate ownership over multiple generations. So what is heirs property? Again, heirs property is simply real estate that is owned by multiple family members, each of whom have inherited their shares. In this family tree, this is a very typical family tree. It starts at the top with our two original family members. Let's imagine for today that it's a married couple. And then the next row is children, indicated in Black. And 3 of those children have gotten married. Still very normal family tree. The next row, which is in the color yellow, is grandchildren, very normal. And then there's even some great-grandchildren in blue. So very typical family tree. And if we imagine for today that the original couple at the top of the tree was a married couple, and like many Americans, they passed their real estate intestate, so without a will. And imagine that everyone in the family from top to bottom who has a tombstone, so the little tombstone in some of those circles, has passed away intestate without a will, and that they've passed away from the top of the family tree to the bottom in that order. So making it a very simple scenario. Thinking about this progression of death, or procession of death, and the ownership, and thinking about intestate succession laws, I'm curious to how many people you think own the property today. So if we imagine that folks passed away from top to bottom, and that the folks who passed away are indicated with the tombstone, how many owners do you think we have today compared to the original 2 owners? And Dean Rushell, I don't know if you're able to see comments, but if anyone chimes in, that'd be great. I'll give folks a few seconds to think about this and then reveal the answer. Anything in the comments or chat box?
Nope, I would say keep going.
Okay, great. All right. So now this is based on North Carolina intestate succession law, where I live. And in North Carolina, under those circumstances, we would have 16 owners. So the number of owners increased over generations. And this is surprising to a lot of people that we went from 2 owners to 1 owner to 4, and then ultimately 16 owners. That's a function of the inheritance laws, because it passes real estate to multiple people. So in North Carolina, if we look at intestate succession in North Carolina, and quite frankly, all states, I have done a legal survey of intestate succession in all 50 states and DC. The law tends to first look at spouses and children, and the amount of, or the percentage or proportion that they inherit with others depends on their role in the family. And with spouses, it can even depend on whether you're the first spouse or a successor spouse. It also depends on if they're children or descendants, and descendants of any deceased children. I've even seen in states where If a spouse is a successive spouse, a second or third spouse and has children with someone else, their share is less because of that fact. So the intestate succession laws are quite confusing, but also create a lot of owners over time. So let's talk about the legal structure of heirs property. As we know, the original couple in our family tree, they owned it as a married couple, and states tend to favor co-ownership of real estate by married couples and provides a specific legal bundle of rights in which the surviving spouse inherits the property. In North Carolina, we call it tenants by the entireties. And that's a very unique bundle of rights, just like joint tenants with rights of survivorship is a specific bundle of rights. With heirs property, they own it as tenants in common. And that, as we know, is also a very specific bundle of rights. So what you're inheriting is not an undivided interest, meaning you don't get specific acreage. There are no survivorship rights amongst co-owners. Any owner has the right to transfer their individual share to whomever they want. And it requires unanimous decision-making, which I don't know how many of us are on the presentation today, but if all of us were trying to make a decision about where to go to dinner, it could take us a while. Imagine if all of us were trying to determine whether we should harvest timber off the property or whether we should try to get financing to replace the roof. It can be very difficult to make a unanimous decision. Another right that exists in this particular bundle of rights is the right to seek partition. So partition, as some of you probably already know, partition is a legal proceeding. In North Carolina, it's handled by clerks. It's not handled by judges, but it's a legal proceeding in which a co-owner can seek the court's support in extracting their interests out of co-ownership. And so when they pursue this, the court has to determine whether the property can be physically divided, proportional, and equitable to everyone's share. And if we go back to this family tree and look at the different owners, we know that they have different shares in the property. And let's imagine that, okay, we have 16 acres and let's say that, or 16 owners, and let's say it's 40 acres. Well, we know 40 is divisible by 16. However, land is unique. Land is very special. And it's quite possible that because of how many owners there are and the different percentages that they have, but also the natural characteristics of the land, it could be impossible to physically divide the property proportional and equitably amongst the co-owners. And so if the court cannot physically divide the property, the court has to sell the property. And historically, and actually in most states, although that's about to change, in most states, the partition sale action happens at auction. So similar to a foreclosure, the property is put on for auction, and in many cases, the proceeds yield are much lower than what they would be if it was sold in the open market. And so not only do we see the actual loss of ownership of this intergenerational asset, we also see the loss in value of that wealth. So even though the family members the co-owners are entitled to the proceeds, not only is it yielding a smaller amount than what it's worth in most cases, but the proceeds also have to be used to pay the cost of the appraisals and surveys, et cetera, in the partition action. So it can be quite devastating, and often is quite devastating for families. What we've seen in the Southeast is an incredible amount of heirs property lost through partition sales. And those sales have often been pursued by third parties who are not family members. Because of this right to transfer an individual share, third parties will look for heirs property that necessarily has an incredible amount of owners or an incredible amount of interest that cannot be easily divided on the physical land, so that they can pursue the purchase of it through a partition sale and get it for much less than, say, going directly to the family, seeking unanimous decision and paying market price. And so if you think about the Gullah Geechee corridor that stems from the southern part of North Carolina all the way to the northern part of Georgia along the coastline, I would say in the mid 1900s, a lot of heirs property that had been owned by families that descend from formerly captive people, enslaved people, they lost their property to partition sales that were pursued by developers. And so now we have all these nice resorts and beach destinations that historically were heirs property. So it can be pretty devastating. So how do we make co-ownership of family real estate work? In my view, and the view of many attorneys who do this work, the best strategy for co-ownership of family real estate and the best strategy for maintaining real estate within your family over generations is to structure the ownership through an entity and not through individual people. And typically we look at trusts and LLCs first, but quite frankly, it really depends on the state where the entity is formed and the different rules related to that. But there are certainly numerous entity options that can be considered. And having entity-centered ownership allows the family to make its own rules for how the property is managed, who's in charge, who's entitled to benefit from the property, how is money, collected, distributed, et cetera, how decisions are made, et cetera. It gives the families a lot of power to create an ownership model that is supportive of not only the land itself, but also the family and the unique family dynamic. So that's the goal. That's the primary strategy that we pursue with heirs property and stabilizing the ownership. But oftentimes, and we'll talk about this more later, oftentimes before we can get to the ownership structure, we have to first confirm who the owners are. The owners have to agree to this new ownership structure, and we have to confirm who those owners are to even have legal decisions. And oftentimes with heirs property, there has not been a title opinion by an attorney to confirm who the current owners are, meaning that the family has cloudy title and have had cloudy title for quite some time. With the cases that I worked with, the last record of ownership was often in the early 1900s. And so I would have to do a title search to create a paper trail. And the tool that I use to do that is the family tree. Family trees give us a lot of information that's not only helpful for the family and understanding the family story and legacy, but for clearing title on heirs property, the family tree is quite essential because the data points in that family tree allow us as attorneys to then go get the necessary records and build a paper trail and confirm who the current owners are and what their percentages are. So oftentimes I would present on heirs property to landowners, and folks would come to me and say, hey, we want to put our heirs property into a trust or LLC. Can you help us? And then in the intake process, we would discover that they don't have clear title, and that would be the first step. And clear title, as you'll learn in a minute, of heirs property is quite challenging. But first, let's talk about the alternatives to creating a new ownership structure that's more secure. You could, of course, enter into a tenants in common agreement. So that's a contract. I do think tenants in common agreements can be useful, especially in the interim period while we're trying to figure out what title is and then also figure out what the next ownership model will be. A tenants in common agreement could be useful for that, but I don't think it should be a standard for co-ownership because, of course, as owners die or, contracts can be broken. I'll put it that way. So I don't think it's a solid solution for long-term co-management. And also the owners change when people die. Individual estate plans. So people will often talk about heirs property being caused by lack of having a will. If you think about a will, and if you've ever looked at a will or inherited from a will, most people who have multiple family members leave their real estate to multiple people. So wills actually create heirs property. And then estate plans are personal to the individual, meaning that it's not something comprehensive that addresses all of the individuals at once. Instead, it just addresses a single individual. And it's not practical to rely on your co-owners to have estate plans that align with yours. So I don't think that's a strong alternative. However, I do think on an individual basis, it makes sense to have a individual estate plan that addresses your ownership interest to, at a minimum, decrease the complexity of the heirs property ownership. And by that, I mean, if someone is an heirs property owner and is, wants to ensure that they don't create more complications, they could consider just leaving their property to one person, or leaving the property one person in their immediate family, or leaving the property to another co-owner. So that certainly can be addressed in an individual estate plan. You could, of course, also maintain the current situation, which in my experience, most families do. A lot of people find it very overwhelming to address this, not only because of the legal complexities and, quite frankly, the cost of legal fees, but also family dynamics. Some people feel paralyzed in trying to navigate an issue as complex with family members that they don't really get along with or don't know well. Oftentimes we see generational order come into play, even though people can be from different generations and co-own and have the same rights. So maintaining the current situation is what I would say most folks do. Physical division is another alternative, and that's where you physically divide the property based on the owner's shares. Of course, if all of the owners are confirmed and make the decision on how the parcels are divvied up, it can look different from what the actual ownership interests are. But I would say, by and large, physical division of heirs property is diminishing the total economic value of that intergenerational asset. It also is opening up, really creating the opportunity for additional parcels that are owned as heirs property, understanding that most likely those individual parcels will then be passed on to multiple people. Getting services, if you have agricultural land, when you physically divide and have smaller parcels, you have to compete with those with larger parcels. And so the practicality of getting services on the ground diminishes when you physically divide property. Of course, again, you could pursue a partition action and seek the forced sale of the property. So I want to look at this map. I hope this is big enough, but this map was developed by a coalition of organizations in North Carolina who wanted to understand approximately how much heirs property we have in North Carolina. And the way in which they did that was Wake Forest Law School and Winston-Salem State University, which has a spatial justice lab, so a GIS program that in which students do mapping. So they got together and they pulled tax rolls from different counties. We have 100 counties in North Carolina. They pulled tax rolls from different counties and made guesstimates about other counties that were similar. And this map illustrates how much heirs property there is in North Carolina. And it's overlaid with data around where African Americans live in North Carolina. So I'm actually from Western North Carolina. I'm a mountain girl. The Appalachian Mountains, very proud. And in the eastern part of the state is where we see the highest proportions of African Americans residing. And you can also see here that in that same area, we see a lot of heirs property. And I think that's a pretty significant visual, because if we think, again, if we go back to the early 1900s, late 1800s, early 1900s, and the violence that was occurring against African Americans, even in our legal system, records being destroyed, courthouses even being burnt down. A lot of African American families did not want to avail themselves to the legal system by administering estates. So I'm not surprised that we have a lot of heirs property in the areas where we see a lot of African Americans. For many families, it just wasn't safe to participate in estate administration and other legal proceedings because it could expose you to harm and to risk. But certainly there's a lot of heirs property in the western part of the state, which is largely Caucasian, and a lot of the heirs property in western North Carolina is owned by land-rich, cash-poor white families. And that fact in particular, the fact that there was so much heirs property in western North Carolina, drew the attention of Audubon, North Carolina. They reached out to me several years ago wondering about this issue and how could they address it, because for them, when these mountainous parcels were being, or these parcels on mountains were being acquired through partition action, they were being developed. So people, real estate developers were coming in and using partition action pretty aggressively to acquire beautiful properties that were owned as heirs property and using them to build houses that, essentially impacted bird habitats. Audubon then worked with me and a couple of others to form a coalition to pursue the Uniform Partition of Heirs Property Act, which we'll talk about in a second. But that coalition is mostly made up of conservation organizations, and including the Conservation Trust of North Carolina, Triangle Land Conservancy, the Black Family Land Trust, Wake Forest Law School's Environmental Law Clinic, the Land Loss Prevention Project, and more. Now, look at this map and remember what it looks like. And then I'm going to move to the next map. And this map was produced by Southern Environmental Law Center, and it wasn't produced in the context of heirs property, but I thought it was interesting to look at in thinking about heirs property, and thinking about communities that are overburdened by different activities. And so this map illustrates waste, but it also illustrates coastal flooding. And once again, we see an incredible amount of activity in Eastern North Carolina. And if you'll recall, Eastern North Carolina is where we see the highest proportion of African Americans. It's also where we have a lot of agricultural land, but there's a lot of confined animal feeding operations. We don't regulate chickens in North Carolina, so there's not significant data to illustrate that, but I'm sure that it would be much more populated, probably even just covered all at chickens. But there are a lot of CAFOs that aren't shown on here. There was a pipeline that was proposed to come through the Eastern North Carolina area. And then we also see the coal ash sites and coastal flooding. I think that's particularly striking, thinking about intersections of systemic issues. Heirs property owners have very vulnerable ownership and as tenants in common. And when they're in communities that have other issues that they're impacted by, that compounds their challenges. And especially makes it more difficult for them to be stewards of their land. So there are a lot of incentives to address the challenges, and I think that the incentives go beyond the individual family owners. I think the incentives also are for all of us, especially those of us who are working in the conservation and environmental justice space. When you have clear title, when you have secure ownership and a secure decision-making process, you can be a great steward of your land. You can get access more easily to resources. And so incentives are, for forestry and traditional ag, the different conservation opportunities that exist. Of course, intergenerational wealth and stability is an incentive. It's also a form of affordable housing, to the extent that there's no debt on the property. When families can maintain housing over generations, that's significant. It's also gives you easier access to disaster recovery. And of course, when you have clear title, you're better able to confirm legal standing to address environmental justice issues, as well as other issues. I find that a lot of heirs property owners are subject to boundary disputes and other types of disputes related to their property. But if you don't have clear title, it can be difficult to pursue relief in court. So there have been some policy solutions. The first one is the Farm Bill 2018. So historically, heirs property owners were not allowed to obtain farm and tract numbers. And if you're not familiar with a farm and tract number, I think of it as like a social security card for your farm. Having a farm and tract number is often required to participate in USDA programs. And one of the areas of the criteria are proof of ownership. So heirs property owners that cannot prove they own the property were unable to get farm and tract numbers. Well, that changed in the 2018 Farm Bill. The 2018 Farm Bill had a provision that said that heirs property owners can get a farm and tract number, and it laid out what the proof of ownership criteria are. We're going to talk in a second about the Uniform Partition of Heirs Property Act, but in the Farm Bill, they had a set of criteria for farmers in states that have adopted the Uniform Partition of Heirs Property Act, and a set of criteria for farmers that are in a state that have not adopted the Uniform Partition of Heirs Property Act. I think that's significant because from a legal perspective, there's no tie to the uniform partition, or let's say there's no tie to partition and farm and tract number. However, I believe that our policymakers determined that creating that link could actually incentivize states to pass this legislation that's protective of family land, because a lot of states are reluctant to pass the Uniform Partition of Heirs Property Act. So kudos to our Congress people for creating that provision in that manner, because I will say that in states that have not passed the legislation, the criteria for demonstrating proof of ownership, in my view, requires working with an attorney, and that shouldn't be the case. People should be able to just produce the documentation and get a farm and tract number. The other provision that the Farm Bill 2018 is a loan program to resolve legal issues. So essentially it stated that the secretary could loan money to qualified CDFIs, so community development financial institutions, who could then make loans to heirs property owners to resolve legal issues and do buyouts, et cetera, related to their heirs property. Personally, I feel that a grant program makes more sense, but I'm not complaining. I think it's great that the federal government is seeking to create ways to obtain money to address the legal issues. The program launched last year. However, it's my understanding that it's on hold again. So we know the Farm Bill 2023 might be delayed or is delayed. There's also different laws related to CDFIs, and it's my understanding that the laws around certification of CDFIs have changed, and so the heirs property relending program is on hold until the CDFIs have been designated can get recertified. It's my understanding that most organizations that are doing policy advocacy for the 2023 Farm Bill are not seeking change to the heirs property provision because we just haven't had enough time to see how well it's working and to see if the provisions are actually opening up access. So I think it'll take some time, but I think it's so good that our Congress people made this legislation and opened up opportunities for heirs property owners. FEMA similarly did not have or had proof of ownership criteria that was necessarily exclusive of heirs property owners, meaning that the documents that they said you could present were not inclusive of something that heirs property owners could present. So they did expand their criteria in 2021. I think it's still early days to see how effective it's been. I know that there have been some articles expressing that it's been effective. I think we still need some more time to see. I think the criteria, the documents that the criteria set out still are likely difficult for people to produce. And therefore, I think it's really important for people, especially people in heirs property owners in disaster-prone areas, to be proactive in understanding what documentation is required and seeking that documentation and putting it in a safe place. Quite frankly, I think that safe place would be the cloud, but I understand that not everyone has that kind of access to the internet. And so perhaps it's a fire safe or with a trusted professional. And then we had the Uniform Partition of Heirs Property Act. So the Uniform Partition of Heirs Property Act was promulgated by the Uniform Laws Commission. And the idea was to provide an additional layer of due process rights when a partition action involves heirs property. And so the first thing that the legislation does is that it says if the property is being if the property subject to a partition action involves heirs property, an appraisal should be done to obtain the fair market value. And then once that's done, the non-petitioning owners have the opportunity to buy the shares of the petitioning owners. So they get a first right of refusal. And if they are able to buy out the shares of the petitioning owners, then the partition action stops. I think that's tremendous because it is a form of dispute resolution that has a good outcome that gets people out that don't want to continue owning, but doesn't force the family to lose the property or try to bid on it at auction. If, however, the property, if the petitioning owner's share is not bought out, then and the court determines that the property has to be sold and cannot be physically divided proportional and equitably, then they can proceed with a partition sale. However, the sale must be on the open market. And so an open market sale allows the family to realize as much of the value of the property as possible, whereas the auction did not. So linking that back to the Farm Bill, what we've seen, and again, is that a lot of states have, actually, I didn't say that earlier, sorry. What we've seen with the Uniform Partition of Heirs Property Act is tremendous support for it across the country. I believe to date, there may be 22, 23 jurisdictions that have adopted the Uniform Partition of Heirs Property Act, and they've been very diverse. So we have DC, which is a very urban area, not likely pursuing that because of the Farm Bill connection. We have New York, which of course has one of the largest cities in the world. And there is an incredible amount of urban partition actions, urban heirs property loss through partition actions. But New York also has a lot of ag land. Montana, Texas, Florida, California, a lot of very different areas. And then the South, almost all of the states in the South, except my home state, Pooh. But a lot of the states that have passed this legislation have been successful in doing so because of the tie to the Farm Bill, this belief that farmers who have heirs property should not be penalized and restricted from obtaining access to USDA resources simply because of their form of ownership. And so what's been wonderful to see is these coalitions of conservation folks, real estate folks, lawyers coming together around this issue and supporting heirs property to get this legislation passed. Again, we haven't seen it passed in my state, despite the incredible amount of heirs property and despite the significant natural resources in our state. Happy to talk about my theory on why, if folks have questions about that. So let's talk about the real problem. In my view, the real problem that's at the forefront of heirs property owners is title. Again, a lot of the families that came to me because they wanted to secure their ownership and put the ownership into an entity, they had cloudy title. So while they were coming to me for one type of legal services, we had to start with a different type of legal services. And unfortunately, the families would exhaust their resources for legal services on clearing title. One of my most memorable, actually my first heirs property case where this happened, the client, I didn't hear from him for quite a while. I had done a substantial amount of work. He paid me, and then I didn't hear from him for quite a while. And when I did, he told me that he had to choose between paying the property taxes and paying me. And that was heartbreaking. But that's certainly not the only time I've heard that, where people just forego because they can't afford it, and they won't actually realize their goal of securing ownership. So when you have confirmed ownership, you can defend your rights against others. You can make sound legal decisions. You can build a strategy. You can access resources and relief, and you can increase the income of the property, the value of the property, and optimize the management. That's not the same when you don't have confirmed ownership. And so that's why, together with my co-founders, I founded HeirShares, because when I was doing this work as an attorney, it was, quite frankly, it was painful to me that my clients, although I was able to help them clear title, they couldn't go any further. I will also say, just being honest, since I'm amongst legal company, the process of clearing title on heirs property is very draining. I love the stories. I love the intake process. I love learning about each family's family tree. I love visiting their land. But in practice, clearing title is quite complex. I don't know about the folks in the audience, but I'm not great at math. And doing fractions and percentages, I would always have to call my friend Otis, who's a mathematician, to help me figure out the ownership shares, the value of those shares. It just took a lot of time. We're having to source information from multiple jurisdictions. Most of the families, actually all of the families that I worked with, were Black families in North Carolina. And if you think about the Great Migration, which was this period in the early and mid 1900s, in which Black families spread out and spread north and Midwest and even West, because of the violence that was happening in the South. So those folks in the North, our cousins, our city cousins in Chicago, our cousins out in California, they co-own the property with us. And so when that happens and they die and their interest, we have to go to those jurisdictions to get the documents to demonstrate what has occurred. We have to get the vital records, death certificates, birth certificates, what have you. And so the process of clearing title is quite cumbersome, expensive, and takes a lot of time. And so I had this hunch or this belief that technology could play a role in clearing title. We have so many amazing applications out there. I mean, Google search engine alone is brilliant. Now we have ChatGPT, which I don't know a whole lot about, but my sister who's sitting here with me does, and we start thinking about how that can help clear title. But anyway, I feel like technology could actually help us make systemic change in how families co-manage and how they and their attorneys address clearing title of heirs property. And so that's why we created HeirShares. And the first tool that we are building is a tree builder app that will facilitate the collection of data for the family tree. And meaning that it will facilitate crowdsourcing the data, and also ask the users a series of questions that they input, and it builds a family tree. And in the background, we can see, or not in the background, to the side, we can see the family tree being built. And in the background are algorithms that were built using intestate succession laws and some other laws, are making predictions about how ownership is changing. The output is a comprehensive report and a family tree. So the attorney who is tasked with clearing title will get to see not only the family tree, but they'll see a timeline of events that trigger analysis of ownership change. And they'll see predictions of how that ownership changed, along with the fractions. So it'll do the math as well. So if we look on the left-hand side of the chart, On average, it costs about $5,000 for my clients to clear title, and it would take about 2 years to do it. I'm a solo practitioner, as are many of the attorneys who are working on heirs property issues, along with legal aid and pro bono attorneys. The families are often underinformed about rules of heir ownership. The process is pretty nebulous for the families, and it's quite a burden for attorneys. With HeirShares, our hope is to significantly reduce the cost of clearing title. So our software will be offered as a subscription. So that's called SaaS, software as subscription. And we are estimating that it will take about 4 months of family crowdsourcing to build the tree. And they'll get a detailed explanation. There's transparency and ownership of the process by both the landowners, but they can also involve their attorneys, and they should. And actually, I think, or not, I think we hope that attorneys will leverage this product as a resource for their clients and as a way of working with them. And then we also believe that it will reduce the workload and provide a detailed ledger. I already talked about how the app works, but essentially, think of it as think of the user experience as a hybrid of TurboTax and Ancestry.com. But basically, the account owner will create a profile and add property information. And then they can invite users who enter family data while HeirShares algorithms making some predictions, and then they get the comprehensive report. And our hope, again, is that families will use it and law firms, but I also believe that the USDA and other service providers like landowner organizations will use this app as a resource for heirs property owners. And that's it. I'm very curious to see what questions you have or any discussion that you want to have next.
Thank you. That was super interesting. What a clever solution. Okay, so for our audience, we have a few minutes to take questions. And again, just enter your questions in the chat or comment space, and we'll get through as many as we can. If you're looking at your screen and saying, I don't see where to enter questions, you may be watching on the VLS Live page instead of on YouTube or Facebook. So those are the sites where you'll be able to enter questions. Okay, so I'm going to kick it off with a couple questions we've received already. Thanks so much, Mavis. Are there other aspects of the Farm Bill beyond the ones you mentioned specific to heirs property that relate to and could help support heirs property owners?
I don't actually know the Farm Bill very intimately, but I do feel like some areas of opportunity could be around conservation easements, or the conservation easement program that the USDA has. And then this is not with the Farm Bill, but there's also federal legislation, and I'm blanking on the particular law, but there is a set of laws that applies to banks in which they are required to address or give back to their communities. And I feel like that's a law that could change, that would actually put more dollars into local communities that have heirs property and resources for heirs property owners to get legal services, et cetera. But unfortunately, I don't know the Farm Bill in and out. I only know that one part, quite frankly. I have looked at other parts. But I will say this, I do think that, or what I have seen and what others have seen when looking at heirs property owners, is that often their parcel sizes are smaller. And we know that large parcel owners often get more resources than smaller parcel owners. So I think anything that can address those kind of inequities can help advance heirs property owners, as well as others, quite frankly, who have smaller parcels. I mean, that could even be something like segregating equip pools, where, for small landowners versus large landowners.
Great, thank you. And I was just smirking before because I know very few people who could say they know the Farm Bill in and out. It's such a massive beast. Okay, next question. Thanks very much for an informative talk. You mentioned both pipelines and CAFOs. Have you encountered issues with factory farm gas, biogas pipelines?
So I personally have not worked on a matter of involving heirs property and the gas. And I think I know what you're talking about, but I may not. But I did meet an heirs property owner in North Carolina whose their family was next to a CAFO. And in North Carolina, at least, it's legal for one of the ways that these CAFOs, I guess, manage the waste is that they spray it. And so they were spraying this family's property with literal shit, with poop. And the family kept trying to fight it. And North Carolina also had a cap on what you could recover for that kind of nuisance. And so that not only did they not have clear title, but the amount that they could recover was so low. So yeah, that's the only example that I've heard. That's actual poop, but I think it's similar in terms of the nuisance and the damage to the property.
Yeah, great example of why having clear ownership rights in place so that you can address those kind of crises when they come up. And you don't have 2 years to clear your title before being faced with that kind of problem. Next question. What are the reasons for the reluctance to pass the Uniform Partition of Heirs Property Act?
Greed. That's my very accurate but biased opinion. So I will say on the surface, what has been expressed is that it's overburdening to court systems to add those additional provisions. And I think that's BS. Just using North Carolina as an example. So in North Carolina, clerks have jurisdiction over partition matters. I point that out because you can become a clerk at 18. You don't have to have a law degree. It's an elected position. But anyway, in North Carolina, clerks have been very vocal against the act, saying that it would create more work for them. But it actually would reduce the amount of work that they would have because they get to task an appraiser, a real estate broker, a surveyor with doing all the work. All they have to do is approve, what approve or not approve what they propose to them. So that's on the surface, that it's overburdening the courts. And then in my view, when does public good outweigh the work that our court system has to do? I believe underneath that, though, is greed. Some of the most powerful people, and just using my state as an example, some of the most powerful people influencing our legislators are people who use partition actions to obtain heirs property. So in other words, they're using they're using a legal proceeding that is meant to address co-ownership extraction to purchase property for a much smaller amount. And so this former legislator has actually been very vocal and has helped the clerks be vocal in our legislature. And I believe it's because he actually benefits from us not having it. In other states, it's been similar, just saying it's not needed. Families can work it out. They can't. Yeah. I haven't heard really good, legitimate reasons. That I will say, Louisiana is the only state where I looked at their partition law where it seemed like it was okay. Like it wasn't incredibly disadvantaging heirs property owners, but they could still improve it with the legislation.
With just a couple of minutes left, I'll pose the question. You focus on land that is in a family and passed down for generations. Can you speak a little bit to the relationship between those issues and the issues faced by people that want to newly own farmland and some of the challenges of accessing land from that perspective? In the community, Is that also a challenge?
Access to farmland?
Yeah, accessing farmland, buying farmland for the first time, not that's being passed down through the family.
I think it's challenging. Yeah, I mean, of course, the market has a influence on, the market, and how much capital you have has an influence on it. I mean, land is not easy to maintain. It's expensive to farm. So I think from a practical perspective, it's financial. I will say that more recently, I've been doing some work in the Northeast in New York, and I met with some new farmers and folks who had just acquired land, by direct sale. And I asked them, what about succession planning? What's your plan? Are you owning it as individuals, et cetera? And they're like, oh, I got too much to focus on. I can't do that yet. And so I do think it's upon the legal community as practitioners that we reframe what it means to have a multiple generational farm, and we coach our community to do succession planning. I mean, you do succession planning with any kind of business, and the same is true for farms. And I think Montana is a wonderful example of state laws that are supportive of succession planning, and having that kind of norm. I think that should be across all states and jurisdictions, where we as a profession advocate for succession planning and strategies that ensure that ownership can't be compromised down the road. I think when you're new to ownership, it's hard to think about when you won't be an owner or won't be here anymore. So it's important for us as attorneys to educate people.
Great. And before we wrap up, I'll just take the opportunity to plug on the legal services side. In New England, we have a program called Legal Food Hub, and VLGS runs the Vermont office of the Legal Food Hub. And so folks that qualify, that are, seeking to purchase farmland, running farms, running food businesses, it's really a wide gambit, can access free legal services for things such as the legal side of succession planning. Of course, there's lots of other awesome service providers on succession planning in the area as well. So
that's awesome.
Yeah, feel free to direct
when you're all expanding to the South.
Right? Yeah, we should talk.
We should talk.
All right, everybody. Thank you so much for joining. Thank you, Professor Gragg, for your presentation. And if you'd like to join for the next talk, it'll be next Tuesday, same place, same time, online. Thanks again.
Thank you.